Hi, this is Tim Evans with TX Coffee News TV. Welcome to another installment. Today we're going to find out how to find a good patent attorney in Dallas-Fort Worth. I have Warren Norrid on the line with us. He is professional engineer and patent attorney in Arlington, Texas. How are you, Warren?
I'm good. How are you, Tim?
Doing great. So let's get down to business. Tell me, so how does someone find a good patent attorney in Dallas-Fort Worth?
Well, first of all, you probably always want to start with the obvious thing. Ask your friends who are involved in this kind of activity. Whether you're looking for a dentist, you might look at your friends that go to dental work needing a dentist. If you're looking for a patent attorney, or you have an invention and you think I need to probably see somebody about protecting this, you want to talk to your friends who are engineers that talk to other patent attorneys. Of course, you want to look at people who are working with you at your level. So if you are a 6,000 person business, you're looking at a different group of people than you would be if you're a beginning entrepreneur and inventor. You want somebody who knows your level of needs. So you want to look at people who had at least some experience in litigation. They don't have to have been actual litigators themselves, but if they're a patent agent, meaning they're not a patent attorney, they may be perfectly good, but they have to have at least been part of a team that's been involved in litigation. If you've not ever been part of litigation, then you don't know the kind of problems that can come up. A patent agent or attorney can get you, can go through the process and get you a patent that's been issued and find out that it's not worth very much because it's been written in such a way that somebody can infringe without actually being actionable, so that nobody can really sue them for it. So it's a problem that happens quite often. You want to make sure that whoever is going to do your patent work does a patent search first. If you don't have a patent search, then you could be wasting your money. You can spend $1,000, $1,500 on a patent search, or more or less. You're going to get what you pay for. But what you don't want to do is skip the patent search. And there are a number of patent attorneys and agents who will do this because it's more money to just do the patent for somebody. The problem there is that now you find out there's already patent on your invention and you've wasted your time. So get a patent search done first, and if a patent agent does not want to do a patent search, then you've probably chosen the wrong person. I and a number of other people would consider it almost malpractice not to do a patent search first. Opinions vary on that, but a lot of us would say if you don't get a patent search done first, you're making a serious error. A couple of other things that you get out of a patent search, make sure I defend this position properly, is that you learn what else is out there so you can write the patent to avoid the prior art, the things that are already out there. The other thing that you're doing is you're making sure that you can have a freedom to operate. That's sometimes part of a patent search and sometimes not. But if you're going to go through the process, if you're going to spend thousands of dollars to get a patent on an invention, you want to at least hear certain words once or twice before along the way. Is your invention novel and inobvious? Is this a non-provisional utility patent? If you don't get a full analysis of these words at least one time, then you're not really being treated as a serious individual. Another couple of other things, I'd say look for an attorney who has real engineering practice. You have to have a technical degree to get permission to prosecute patents, and that's what we talk about. You're prosecuting a patent, and you have to get permission from the USPTO, United States Patent and Trademark Office. And so they only allow people to do that if you have a technical degree. But you don't have to have any real-world engineering experience to be part of that process. I would suggest to you that if you have a real engineer who's gone into the practice later, then they hear the words that you're using. You use the word voltage, they know what you're talking about. You use the word water pressure, and they know how these things are measured. It's important to understand really what's happening instead of just having a patent agent that's going to take the words that you give him and just put them on a page and hope for the best. You want a patent agent who will take the invention, understand it, and expand it to be as broad as possible. One other thing I'd say is if you see somebody who says, I'll take care of you right now. We'll get it done in the next week. It's going to cost you $3,000 or something like that. That person's too desperate. You don't want to go with somebody like that. That person needs business too badly. They're not going to do a good job for you. I've never seen a job that gets done that fast with that amount of money that's going to be any good. You're spending money for an invention that you hope is worth millions of dollars. Don't be penny wise and pound foolish. One other thing that I'd say is stay away from invention promotion organizations that advertise on TV. These people treat their clients so badly that there's a federal law that was passed a few years ago so that they have to give you certain amounts of information. Stay away from anybody like that. People like the idea of using an invention promotion organization because they think that this organization is going to help you promote your invention after they get a patent. The number of people that most of these organizations have actually helped can be measured on one hand using your fingers. So I'd stay far away from that. And that's how I would go about advising people how to find a patent attorney.
Wow, it sounds like a complicated process, but so it's really they need to have a professional degree, right? A professional engineering degree.
Well, they don't have to have a professional engineering degree. I have one, and there are very few of us that have that, but they do have to have at least some engineering experience.
Okay.
So,
okay. So but real world experience is preferred. So how would they do that? Would they go online and check out the website and see what type of engineer do patent attorneys typically talk about that, or what? Give me a little feedback on that.
Usually, a patent attorney will have his background on his website, and not to say that you can't be a good patent attorney without a good website, but those of us who are proud of the work we've done, you can usually find us on the web. You can usually find what our backgrounds are. You don't have to have exactly what somebody's had. If you got a mechanical patent, an electrical person, a person with an electrical background can probably help you with that invention. But if you've got a very complex pharmaceutical patent that you want to talk about and have patented, then you're going to want to talk to a patent agent who's comfortable with that. So just get their background. You want to be able to look these people in the eye and say, have you ever worked on this? And whenever you describe what you're doing, you want to see that the attorney that you're talking to understands what you're talking about. If they don't really understand it, then they're not going to be able to defend your patent, your invention. They're not going to be able to describe it well enough so the patent office can really see what's being invented and really see the broad scope. It's easier to grab a patent that's very small, that handles a very small, narrow invention. The job of the patent attorney is to kind of expand that and say, what else can I reach out and do with this invention so that you're going to get the maximum benefit of the patent.
Okay, well, thank you for that. So I know you do some great things for your clients. What would that look like for our readers or viewers today?
Well, we have a four-step process. We start with the identification of what intellectual property that the client has developed. That can be, usually they come in and they think it's a patent, sometimes, and usually it's a patent, but sometimes it's a trademark or a copyright they really need. The second step is we evaluate the status of the person who's doing this. Is it a business? Who's going to own the invention? Is it the business that owns the invention, or will it be the owner of the business that owns the invention? Does the invention, did the person invent this who works for the company, and do they need to assign it to the company? These are all business aspects where it's helpful to actually be talking to a patent attorney instead of a patent agent. If all you need is a patent agent to prosecute a patent, then you don't need a patent attorney. But if you don't have an LLC that's properly formed, if you don't have an operating agreement that's properly put together, if you don't have an assignment process or an employee agreement that says, the person I'm working with that's helping me develop my product is working for me and he understands that I own it, he doesn't. These are questions that we will flesh out while we're talking. So we evaluate that. That's the second step. The third step is to develop a plan. If you don't have an LLC that's properly put together, you don't have to have that right away. you can go ahead and start the patent process. It's a multiple-year process, so we can get the LLC put together. If you have an LLC but you don't have an operating agreement, well, you don't really need that right away, but you're going to need to have that before we get third-party financing involved, because everybody's going to want to know what their part is, and that's what one of the things that an operating agreement takes care of. And then the fourth step is to follow the plan. If that's, it may be that we're going to try to get this invention issued as the patent in multiple countries. That's a different process. So we might apply for a patent here in the United States and then go to the rest of the world, or we may do the rest of the world first. We may have a provisional. So we'll have a plan, and then we'll follow the plan. We've been very successful at this approach. We had this last summer. We finally achieved. We have 54 countries. We're getting one patent in, which was a phenomenal amount of work. But it was straightforward. There's nothing magical, but it's easy to make mistakes. It's very detail oriented. You will spend a lot of time making sure that the I's are dotted and the T's are crossed.
Yeah, sounds like it. Sounds like it. So Warren, if somebody wanted to call you and set up that consultation, what's the best way to reach you?
Well, as you can see at the bottom there, I've given our website and our phone number. I'm very easy to find. There's not a lot of Warren Norrids in the world, and so you just look for Warren Norrid, patent attorney, and I'll pop right up. So I appreciate your questions.
All right. Thank you, Warren. Thank you so much for sharing with us on how to find a good patent attorney in Dallas-Fort Worth. Appreciate it.
Thanks, Dan.